Okay. So thank you all for coming tonight. As Erica said, I'm Paul. I'm state legal specialist. And how do we dim the lights up front?
Oh,
Since
yeah.
I don't know how to do that.
That mean you're a lawyer?
I am. I am a lawyer. I go around and do a lot of meetings. I don't really work anymore. This is what I kind of do all the time. So these are the people that did all the work. So I felt like they should get some credit since they're not here tonight. Madeline is a second-year law student at Mercer. Holiday is a recent grad of University of Arkansas, and some folks in the room may know Olivia Scuderi, whose family is in Montgomery County, and they farm there. She's a second-year law student at American University. I'm with the Ag Law Education Initiative. You can find all our stuff there as well. I'm going to keep going. Erica already said none of this is legal advice. We're all good with that tonight, right? Good.
What if we give you $1?
You can't. It won't work. And that should be playing. This institution is an equal opportunity employer. Everything the university does is open to all. And then, yeah, none of this is legal advice. I skipped that. I got ahead of myself on my slides. All of this is a fact sheet, and I'll get Erica a copy of this PowerPoint slide because I just finished it this afternoon. Before I came up here, and I'll give her a link to the publication. That's a QR code as well. We're working on another one. Olivia's working on one to go through what the condemnation hearing process would look like. With that, this is mainly over the stuff I'm going to talk about tonight with eminent domain. We're going to talk about it from the legal end. And then we're going to talk about where everything is at, because how many people know about the MPRP? I'm hoping everybody in the room does. And as I had to consistently point out to everyone, I'm just a faculty member and I have no control over any of this. I'm just here to talk to you about the law tonight and how that works. We can rant about it when we get done. Leave a little background. Piedmont Reliability Project. We all kind of know what that is. It's a 70-mile high voltage transmission line being constructed to address transportation system reliability in the state. This is one of many that will probably be proposed to be built in the state. I believe I have been told we need 128% increase in transportation infrastructure for electricity just to meet the growing needs of the state, whether they be from data centers, the move to more electric appliances in houses, electric cars, just everything else that's electric in our lives. This is all a part of what PJM, and I'll talk about what PJM here is in a minute, has deemed as needed for the region. We did this same workshop in Garrett County about a month ago. They have a transmission line running through Garrett County. It actually runs through parts of Garrett, Pennsylvania, Garrett, West Virginia, and then into Loudoun County, Virginia. Just kind of where this one runs to. That's one of the many lines that's being proposed. I just picked a map with a line on it. That is not the route for this project. I just tried to find a route that was somewhat easy for everybody to see if they hadn't seen it. So for PJM, the group that decided to do this is the Pennsylvania, New Jersey, Maryland interconnection. They are the largest regional transportation organization for electricity in the US. They manage the wholesale energy markets, transportation, and the reliability of the grid for 13 states and the District of Columbia. It is not just Pennsylvania, Maryland, and Virginia. And I think on the map, next page, I have a map. That is all of PJM. It goes all the way from Illinois, Chicago area, to over here. And touches parts of North Carolina, all the way up to Pennsylvania, parts of Michigan. It is not really all connected. Don't ask me how that works. I just found the map. And that, I should go back. And that's all the main power companies based on the colors on the map for the region. That question's come up before. Any questions so far?
Have you
Yes.
heard of this company called Greenvest?
I have not.
They've been calling me up, offering me free trees. And I met with them 2 weeks ago and they wanted to plant it all along York Road and oh, it's free, but we have to maintain them. And they're going to sell our development rights then to PJM.
I don't know anything about them, but we can talk about that at the end of the meeting.
Okay, but
Yeah.
Are there power lines? Is it still agriculture once the transmission lines go through?
Should be, as long as you can still farm under the transmission lines, it should be. We can
So-
talk about that at the end. So one is eminent domain. It's the state allowing either the government or the federal government, whichever entity, local government, exercising the power to take property for a public purpose, or it's been granted, as we're going to deal with in this case, to a private entity acting on behalf of the government to take it for a public use. The only thing is we're going to talk about within the federal constitution and the state constitution is all that has to be done is the landowner be provided just compensation for their land and it meet that public purpose requirement. Yes, sir.
How would just compensation be determined?
We're going to get to that later.
Okay.
We will get to that and how you can do some of that and then some of the fun parts with things that exist in this state. Some key terms as we get started: condemn, condemnation, that's the use of the power of eminent domain. The condemner is a person using eminent domain. And then the takings is just another way to say eminent domains. In the law, we talk a lot about this with takings when we think about other things beyond this. The exercise, we may think of it within regulatory issues, but that's just another way to say it. It's inherent in the federal constitution. It's inherent in the state constitution. We took this right from merry old England when we broke away. The constitution put limits on that power, both state and federal. This was something inherent in the crown. And when the country was created, they decided to put limits on it. It's in the Fifth Amendment of the US Constitution. Not only do you have a right to remain silent if you're arrested, it lays out how eminent domain works too. And by layout, it's one sentence in the whole clause of that amendment. The Maryland Constitution does it on Article 2. Article 2, sections 40 and 40C, depending on what entity you're dealing with. And I should point out that if any point there's a reference to West Virginia in here, I did not scrub it from the PowerPoint. So I should just tell you right now, I updated the Garrett County one. I think I got all the West Virginias out of this, but there may be one I missed as I was going through this before I left. In both cases, I've already said it has to be for a public purpose. When we're dealing with power lines, that already meets it because it's there to meet the public need to get reliable electricity to them. And then the just compensation that we'll talk about toward the end as we go through how some of this is laid out for them. Okay. To exercise this power in Maryland, a public utility, which if I remember correctly, it's PSEG, is a public utility in this, which is regulated under FERC, which meets the definitions under all this. They cannot exercise the right to use eminent domain until a CPCN has been granted, a certificate of public convenience and necessity. That's granted by a Public Service Commission. That process is required to do any high voltage power line. See, I did miss one scrub there. You don't care what West Virginia requires. It requires 69 kilovolts of electricity in Maryland to do that. This power line, I forget how big it is because the screen there was a picture of me up there and I couldn't see it. This power line is well over that. So it's going to have to go through CPCN and PSC. And we'll talk about where it's at in the process. And I have a lovely timeline that PSC has laid out in all of this. Prior to granting all this, all they can do is negotiate with you for an easement that will potentially help them along the way when they're going to PSC to get the final that laid out. By showing they have enough landowners, that just help lay out where that route's going to be. They cannot exercise any power of eminent domain until that CPCM process is granted, and they are probably a year away from that. Although I'm still not clear because I think there was a typo with the press release and I'm waiting on confirmation. Currently averages, according to the PSC's website, 388 days to grant a CPCN. This was filed almost a year ago, and they are hopeful it will be completed by early next year. So we're going well over that 388 days, but that's an average. Some go longer, some do not. To get that throughout the whole process before it can even be issued, multiple state agencies have to sign off, including the Maryland Department of Ag, Maryland Public. Maryland Planning Authority, DNR have to go through this. I'll show where the public comment periods are towards the end when I talk about the process throughout all this. The public can become an intervener at any point. A lot of this requires you to go through, have an attorney, file with an attorney to go through the process correctly. There are a number of groups, at least with this process. I believe all the county farm bureaus have filed for the right to be an intervener. A number of groups have already filed. They're on Facebook and the internet. You can find them. I did not list them all out here, but they are actively voicing concerns to this CPCN process. One of the things we talk to folks about is if you're going to get involved in this and do it, don't just say, I hate the thing. Have legitimate reasons as to how it would impact your property. There's cultural things there. There's other things it would impact beyond just you don't like it. Any questions so far? Okay. To do all this, they got to go out and they got to compare routes. The state law requires them to look for the most efficient, the most cost efficient, and least disruptive to the environment to be awarded a CPCN. This is when we get to the end when I talk about all the survey work they want to do. That's why they're doing survey work. They're trying to figure out what that the most cost efficient and least disruptive will be to get this. Then once all that's approved, we'll know the route, and that's when eminent domain can start. As of right now, all we're at is an easement stage where they may want to go out and take an easement. I decided to put in just what an easement is in case nobody in the room knew what an easement was. An easement's just a legal right that allows the company to come on the land for a specific purpose. And in this case, it would be to construct, operate, and maintain transmission lines throughout the life of the transmission lines. With that, they'll have the ability to go on, cut trees back that could potentially interfere, keep stuff away from the lines, and have a right just to come on. Once all this is granted to, there'll be an easement across the property as well. So once eminent domain's done, it's the same thing, but right now we're just in a negotiated easement process. They're only going to have the right to come on for whatever that easement allows them to do and for that limited purpose, and they have to stay within the bounds of the easement, even though things may happen to where they have to go beyond it periodically. If there are gates, they may have to have access to get into gates so they can do that. And other things. We have power, well, I guess my parents don't farm that farm anymore in Oklahoma. But at various points, if we did not, as children, lock the gate back correctly, we would get yelled at because the power company would come in and cut the lock. And my dad was never happy with us when they cut the lock because he had to buy a new lock at that point. As a part of that, they may have to come in and, like I said, clear vegetation and restrict other uses that may interfere with the easement, which will be in the easement document as to what that's going to be. So I can't really say a lot towards that without seeing what one is. If we're dealing with this within the easement phase right now, even when we get to eminent domain, and they're starting to try to do this, because as I'm going to talk about, the first thing they have to do in the eminent domain process is try to go in good faith and negotiate with you. Is it in your interest to accept the first offer? It is never in your interest to accept the first offer. Decline it and start seeking better financial arrangements within that. We're going to talk about, I think on the next slide, some strategies. Yeah. We can always have landowners start pooling together and negotiate together. Is it easier for you to negotiate as one person or as a large group? Large group, you have more power, especially when you know where the line's going to go at that point. Because then you can dictate better terms within that. We've seen that work within other things in other states. The biggest example would be within the windmill industry when wind turbines were moving in out west. A lot of the landowners where they were looking at putting them would just pool together and negotiate all the terms together for those lands and end up with better terms within that. And you may be able to get better restrictions on the power company within that. There's one thing within all this, when I get to it, I will talk about, because we have still not gotten it in here, even though we know it exists and we're still working through how to get it put in. But Olivia's had a little bit of stuff to do this semester and hasn't been able to get that done yet. Not to throw her under the bus, but she's just had school to do, and this is like a secondary thing. Like I said, once all that's approved, that's when we can start eminent domain to get those easements. The first thing that has to be done to go through eminent domain is they have to enter into good faith negotiations with you to be able to start using that process. What's good faith? They have to at least be willing to make a deal, and you have to be willing to work with them. They may come in and not be willing. That may be enough in some of this, but there has to be some sort of voluntary good faith argument, negotiations that have gone on and failed to start this process. Any questions so far? It's a good way for me to get a drink of water.
They're gonna run fiber on these power lines, like they did on the gas lines, Williams gas line, all the gas lines in front.
That will depend on the easements. They probably will not be able to do that because it probably will be a power line only easement and they'll have no right to subsurface on it, to go underneath it.
Well, natural gas lines, you can stand this.
With this, it will be for a power line, so I don't think they'll be able to run fiber unless the easement allows that to go through. Yeah. So first, at all points, they have to get an appraisal of the damages to the property, all that along with the good faith negotiations to be able to do this. I've missed that part. With that, all they have to do is go in and look at the area impacted and not to the damage to the property outside the scope of where the easement's proposed. That's all they have to do to get their appraisal. What does everybody in this room assume will happen if you have this running across your your land? Is there gonna be damage outside the scope of the damage there, the area that has the easement? Yeah.
The river damage to the.
They'll have property issues, diminution in property values, other issues beyond the scope. That's on you to bring up. You have to demonstrate that. The company doesn't have to demonstrate that within that. You can talk to them about it in the part of the negotiations, but it's only on them to go with these appraisals, and we'll talk about other appraisals, I think, here in a couple of slides that you can do as a part of that just compensation to kind of figure out what that would look like in things that have worked in other areas. Yeah, we're into it. This feeds into that just compensation requirement that's in the state law, the state constitution, federal constitution. This is where working with attorneys that have experience can help you, because they're going to know what to do throughout this entire process. So one of the things I always talk about with this is, in my prior legal experience, before I came here and became a useless faculty member, as I like to say, I worked for a law firm in Oklahoma. All they did was handle landowner contamination cases with oil and gas. So if you had an old oil and gas well on your property, you came to us. We had to sue the energy company to get the site cleaned up. We had experts on staff that knew the environmental science behind what was happening. If you had cattle out there, we could explain, this is what's going to happen to cattle if they get out there. The other thing was, as a part of the drilling operation, you went through a condemnation process in Oklahoma to build that well site. And you went through a similar process. And guess what we had already on staff to help, or at least knew who to retain to help? We had the environmental experts. We had the people that kind of knew that this is how water is going to change when it comes across your property if you put this well site here. Similar to this, these people are gonna know, who do we call out? Who do we get the evaluations done properly? How are we gonna be able to do this? One thing you can do throughout this entire process, if you're working for an attorney, is get the company to pay for it in the end somehow, like negotiate in attorney's fees as a part of that, or some sort of flat fee to pay, offset your legal costs as a part of that. They may be willing to do that, they may not. It all just depends. There's an option within state law to where they may have to pay. We'll get to that here in a minute. So how can we do this? We can go and get appraisals. We can just show, like, here's what will happen if we have power lines running across it. Here's how it's going to reduce our property values. Here's how it's going to do. We can use the assessed value of the property and show this is what's going to happen. If we put this on, this how it's going to impact the property values of that property, having it come on. We can use some evidence of future uses that the land's suitable for, but we kind of have to have a plan to actually use it. It can be hypothetical or something in the future, but we have already in a business plan, we're going to put this kind of store here and this will impact it. We're doing this type of operation to where we're going to need this, and having these power lines here are going to impact it. That may be one way to show it. We can look at the value of the improvements and how they're going to be impacted by it throughout all this. And we can just do comparisons with other properties. There's a lot of ways to go out and show just compensation and kind of work through that process. We can use other things, such as what I talked about earlier. We can look at what the impacts are going to be just from having the power lines there and how that's going to change the farm and add stuff on to what we have to do to have that come in. Any questions on that so far?
So since by the time you get to this point, there's probably discussion already between the entity that wants to use the land and the owner.
Mhm.
So in this particular case, does the taking amount to a forced easement
Yes,
or, okay?
it'll be a
It's not-
forced easement at that
It's not
point.
an ownership of the land.
It's just a
It just
forced,
forces the easement.
yeah,
Okay,
there'll be a court order with an easement put on the property.
okay.
Any other questions? Yes, sir.
Right. I don't know. Really feel. Think like that. Things like that. So people that.
I believe there are studies out there. I can't tell you what they say, but I know there are studies out there that can be used in this to kind of help demonstrate if it's going to be close to your house. Now there are setback requirements to where they have to sit back so far from your house to kind of lessen some of the impacts, but they can be there. One person brought up when I did this at Farm Bureau, a good point, when they had a power line run through their area, and it's probably less likely to happen here since there's not that much poultry, like commercial poultry houses. It screwed up the electronic system within the house, having all that come in. That because of that coming in, it created other issues that messed up the electronic system within the house and created issues. So there's areas where folks should be looking at, like, what are the real impacts going to be to your property and getting that taken into account here. Yeah. Yeah, because if you don't do that, they're gonna go out and spray whatever is set up for brush and just go out and kill everything underneath it. Or around it that they don't have to. Other thing we look at people and tell them to do is just start taking photos. If you got aerial photos are usually in most farmlands taken at least monthly by USDA. So there's at least aerial maps that exist of your property. And you can just have an appraiser come out and start looking at it and start getting some valuations done now to kind of figure out what this is going to look like. Again, I should only say in Maryland, we're not dealing with West Virginia tonight, but in Maryland, Control F only works in certain situations, not when you forget both states, but in Maryland, same thing. The plaintiff pays the cost of the trial. The plaintiff will always be the condemner. Are you ever going to try to condemn your own property? No, so you'll never be the plaintiff. The plaintiff pays for everything in this. In it, you can recover if you go through condemnation and you have to go to trial. You can recover reasonable attorney, appraisers, and engineering fees. This is only if the landowner prevails on the right to condemn. I have yet to get anybody to explain to me what the right to condemn means. That's the way it's written in the state law, and there are really no examples in state law for me to figure out what that means. I don't know if that means you have to totally defeat the condemnation dispute, or you just have to prevail and get a higher fee within it. What leads me to think that is there's a number of bills before the General Assembly this year dealing with eminent domain. None of them are providing attorney's fees for the landowner. They're applying attorney's fees for and the ability to get just compensation if you're a neighboring property owner and you have a house on that property that's a resident, it can be impacted by it, and you could be able to get some just compensation for that, for how it's going to impact your house. Nobody's looking at attorney's fees, so that's what's leading me to think this is actually for anything within that if you get this, you get attorney's fees. If you're in West Virginia, you don't get attorney's fees. Yeah.
So by the time the process has proceeded to that point, has there already been a judgment that of where the transmission lines
Yeah.
go?
Yeah, there'll be a judgment by that point. There'll be a route by that point, because nothing like that can happen until the route is set.
And that judgment is by the PSC?
Yes.
Okay.
And that judgment can be challenged in court.
So the likelihood of prevailing can only occur based on the terms.
Yeah.
At that point, not on the land.
Yeah. That's what I'm thinking is why, as long as you can get a higher compensation, you prevail and you get attorney's fees at that point.
Okay, so that is a way of winning. And
Yeah.
getting your fees paid for if you can prove that the offer was insufficient.
The offer was insufficient, EMO. As I always point out, in Oklahoma, this was my favorite thing because this was even on land, well sites when you would put a well site in because it followed the same process of condemnation. If you got $1 over what you were offered, you got attorney's fees in the process.
Okay,
So, as I point out, it amazes me sometimes that our state law in Oklahoma was much better written than the progressive state of Maryland's state law in that. It's
But-
confused me a few times.
So-
Yeah.
related question. To get to that point though, somebody's already judged that how did you word it, a fair offer.
A fair offer has been made.
Because otherwise you couldn't get to that.
Yeah. Yeah. They would never take you to condemnation if a fair offer had never been made.
Yeah.
It would be easy to kick out at that point.
And that judgment again is yes.
That would be in district court.
Oh, okay.
Yeah. In this case, you'll go to district court and it'll be the district where the property is located, not any other district.
Okay.
So it'll be Baltimore County, Howard, Frederick County, and I forget the other county. My brain it's late. It's been a long week.
Baltimore County condemned our land for the sewer, and we took it to trial and had a jury trial and won. And the judge said, "Oh, I'll give you $1 and I'll pay for it costs."
Shouldn't happen. The way state law is written, they have to pay the court costs. Because what Olivia's putting together, we have all the costs associated with what it costs to do this, because they have to do a property viewing, you have to go out and see the property, the jury has to be able to walk on it. I should point out, this will always be a jury trial, and the jurors are allowed to go walk the property, view the property, see everything associated with the property. And your county tax dollars do not pay for the jurors that day. If somebody has to go to jury duty next week, if I was on that jury, I would not be paid by the county, I'd be paid by the condemner to go out. They have to pay all the court costs associated with that. Okay. Here comes the fun part. In this case, and I'm still confused. on how, because we have interpreted the state law based on how it's written in this. There is the ability to condemn to grant an easement. You can have it condemned and you can grant an easement across it. There is nothing that limits condemnation across that property. It varies depending on how it's happening. And then I'll tell a story because I really don't care if this is on social media or sent out to people that couldn't come tonight. If the condemnation takes place and the easement was granted, if it was granted before June, on or before June 30th of 2018, the utility pays in the following way. The landowner, the full amount entitled to as if the property was not preserved minus what mouth paid, a county land preservation or other entity. And then they will pay to mouth or the county or the other entity that use mouth funds what would be paid the amount paid for the easement for the portion of the property taken. So they reimburse the easement and you get the rest for how that works. If it's after June 30th, it's pretty much similar. You're entitled to the full amount as if the property wasn't preserved minus what mouth paid or a county land preservation program or another entity using mouth funds. And then the mouth is entitled to the fair market value of the easement, which shall be determined by a qualified appraiser that establishes the ratio of the value of the easement interest to the value of the fee simple interest of the land as of the date of the condemnation. So basically all we're doing is reevaluating how mouth is going to be paid in all of this. You get paid basically more or less the same amount. Mouth's way is changing. And I believe the reason that changes, state law changed that year and they changed the easement documents that year.
Set based on whatever the average value was paid in order to put the land in.
I believe so. If it's, that's only if it goes to, I have to back up. That's if it goes to condemnation. If it goes through mouth, you do the same thing. If you give an easement, you go through mouth, you get it approved, and the same process works. The only time you don't have to get mouth approval is if it goes through condemnation. We have a court order, it gets condemned, that happens. The reason why I'm saying we're reevaluating this is I've had multiple people tell me this was set up for one reason and one reason only in the state law. If we ever needed to change a road to give somebody access to a property, that would require an easement to do that. And I keep pointing out, but you wouldn't go through condemnation to do a road easement for a landlocked property. You would only do that if it was adjusting the county road or this. So we're still confused on some of that. And we're attempting to figure that part out. I've had enough people yell at me over the winter that I'm still confused on how. I think we're right, but I want to verify.
What about the temporary construction uses?
If it's on preserved farmland, mouth would still have to be involved in that and approve that. If you got MET preserved land, Maryland Environmental Trust land, it can still be condemned, and there is no process in the state law to tell me how to modify that. So we know the proceeds would be split between the landowner and MET, and the easement document should lay out how that's supposed to operate. If you have rural legacy program, you can't be condemned. Rural legacy is written in the state law. You cannot condemn rural legacy land. And some of that has to do with because it's in priority preservation areas and there's environmental sensitive stuff in those areas. So we don't want anything going in those areas. So that is the only thing in the state law that cannot be condemned. Do not ask me why we set this up this way with 3 different things to do. I'm confused.
So it does not appear that because there's never been a case law to establish.
We can't find any statute or any reg that says you can condemn that property.
Okay.
Yeah. That's why I say does not appear, because there may be something hidden somewhere in the state agency that we can't find publicly that lets them do it.
Okay.
And it may be in the easement document and we can't, they don't make those easement documents publicly available online.
Okay.
I'll go back because I got a little bit of time. Go back 3 slides. This was the hardest thing to figure out because this is what's written in the state law. This next slide is written into the slide or written into the regs. It never tells you that at any point what's written in the regs is for a negotiated easement and the state law is for a condemnation proceeding. Because one would think the way we're trained in law school, if it's written in the reg, it's helped to explain the law so we know what to do at any point. I had to have mouth attorneys explain this to me because I got confused. Because it's not clear at any point. I'm going back, I should go forward. So this conservation easements on this have been not that much fun. If it's privately preserved, the easement document will dictate how this is supposed to happen. It's written in the easement document as to how these things will be split. And it should be written in the easement document. So if it's through any of the private land trusts, that document will tell you how this is supposed to happen. Okay. Oh, good. I'm going to get done right when I thought I would get done. So the goal is to get done at 7 and leave you guys 30 minutes to ask me questions. So at this point, we can help you find an attorney. I got a list of people that have come forward and said they would be willing to, if anybody wants it, I can pull that list together. I've got it in some emails and I can send you contact info for all those folks. I can't make recommendations on any of them. I can just tell you who they worked for and you can kind of talk to them to see how good they would be to do this. The reason why I do this is they know how to negotiate. They know how to handle a lot of the eminent domain stuff. They're going to be able to work with you, especially if it's going to get to a route. When it gets to the route and your property is going to be impacted, if your property is going to be impacted by it. And like I said before, they're going to have the experts ready to go that can help you with stuff and understand like how to look at that valuation, who to talk to figure out how to get you the best compensation out of that process. And as a part of that, you can always negotiate with the company to have them pay part of the fees or all of the fees associated with that. So where are we at in this entire process? So there's currently a preliminary injunction in place that will allow them to do survey work. That preliminary injunction is currently under appeal. According to the court calendar, it is scheduled anywhere between February or May 5th through May 8th to hear the oral arguments on that appeal at the Fourth Circuit in Richmond, I believe, of this year. On December 19th, they issued another preliminary injunction, this one to deal with the hunting ban on the properties. Hunting cannot be banned during a hunting season on Fridays, Saturdays, or Sundays. If you want to hunt any other time on the property for any other reason, whether it be out with deer damage permits or anything associated with that, if you've been given a notice to do survey work on the property, and I can get you the emails and who you're supposed to talk to, but there's emails set up and phone numbers set up to who you're supposed to talk to make them aware of when you want to hunt on the property, the times you want to hunt. And they are supposed to get back to you within 48 hours to give you notice to whether or not they will let you work with you on that. And at no point are they supposed to limit hunting on the property. They are supposed to work with you throughout the entire process. That was also appealed to the Fourth Circuit, and that is currently not scheduled for arguments. It was just filed in the first of the year, so we probably will not know when that's going to be heard until later this year. I think that one took about 6 months to get set. This one will take about 6 months. Yes, sir.
Wow, until the Fourth Circuit makes their decision, what is the procedure that's government to land? In other words, can the survey crews go out there and survey until
They can go out and survey. They're supposed to provide notice to you as the landowner before they go out.
so there's not.
There's no halt. They didn't issue an injunction to stop the injunction. Until then, they've continued to allow testing and surveying to take place. They did not even, I could not find anything that stopped this one there. It took a little bit to figure out where this one was at this morning.
Can you demand the names of the people that are on your property?
I don't think you can demand the names. You'll just be told how many are coming out on the property and who it will be.
Can you tell them not to smoke when you're on a cornfield in the middle of something?
Yeah, you can tell them that. They shouldn't do that anyway. Um,
Yeah,
works.
they're filming, they're filming.
I forget why. Oh, this was just to give you the terms of the hunting injunction. That you get notice of survey work and you can notify them in accordance that you intend to hunt on the property. They have 48 hours to respond and they are supposed to work with you to minimize the intrusion of limiting hunting on the property. They're not supposed to be able to stop it. I know I didn't call it a hunting ban when it was first proposed, but the court really hammered them that they could not ban hunting. They had to allow sometimes. In fact, they made the two parties agree on what the terms would be for this. Because the court thought the company's notice requirement was awful. It pretty much required you to give them notice anytime you want to do anything on the property. There's one that I took out of here. I have not looked to see where this one is at yet, because I just forgot and I couldn't find the case it was in, because there's like, if you ever go into the federal court system to look at this, there's like 5 cases filed at various points with people challenging it, and you have to figure out which one of the 5 something is at. And this one, I forgot which one of the 5 it was in. There is one woman who has a preliminary injunction against herself in this case, because she has gone out and threatened the people involved in it. She's taken baseball bats to them. She's blocked their truck. She's done everything humanly possible to make herself an intrusion upon them. And the company has gone out and gotten a preliminary injunction against her to stop and leave their people alone. So whatever you do, just don't harass them with baseball bats.
And they can come at you with the chainsaw, you can't even swat them away.
They shouldn't come at you with a chainsaw.
Well, that's the gas companies too.
So with this is what's on PSC's website currently as to how the process will operate. As of this month, they were supposed to file an updated analysis, including environmental review, mapping, field studies, and reports, except for the year of some of the field study issues they had. At the start of next month, there's supposed to be a status update once everybody within the state agencies has looked at this. There'll be the ability for staff at PSC, forget who, the Office of the People's Council within that represents people within the PSC process, and then the Power Plant Research Project, which is in DNR and is required to look at the analysis that the company does and make sure that the environmental studies they do are up to snuff and everything within that. And then all the interveners who have filed will be able to file direct testimony on September 2nd. During the weeks September 21st and 28th of this year, they're going to hold a public hearing in every county where this will be impacted. This could change. If you want to know how it's going to change, PSC has the information on their website, and their website is so much easier to use now that they moved to a new template. It is a lot easier to find information on it unless you actually knew how to use the old website. Then it's a little bit harder. There'll be a rebuttal by the next month, all the testimony with all the parties, and then rebuttals to the comments that have come in, and any updated recommendations. There'll be more rebuttal going on in March due. There'll be evidentiary hearings towards Christmas. Then there'll be post-hearing briefs and then post-party replies from everybody. And then I believe the plan is there will be a route selected by next year, by March of next year. Now I need to say on PSC's website, they say it will be finalized by March of this year, the end of March of this year. I don't see how you do that when all your dates in February of next year. So I think they made a typo, but I'm trying to get somebody to verify they made a typo, because I don't think the process works where they get to set the site before they've gone through all this. So I think somebody just typed a 6 instead of a 7 that day.
So did you say that updated analysis from 2 March?
Yeah.
Is that public?
It should be, I didn't have time to go through the PSC for the filing for this on PSC's website. By the way, all of this is filed under the CPCN cases. And you just have to look for this one and you can go through the records and it should be there. I just didn't have time today when I was updating.
Right?
Yeah. Yeah, and they'll have it all filed. They'll have all the parcel maps that they're looking at in there. At least that's the way it works for solar. I'm assuming it'll work the same way. There's a fact sheet again if you want to scan the QR code, but I'm gonna have it, get it to Erica so we can email this in the PowerPoint out tomorrow. There'll be more stuff going on, and I did exactly what I said I would do. Oh, if you want to join this, you can sign up at Southern Ag Today. We do ag marketing, trade, policy, specialty crops, dairy, livestock, ag law, co-ops, all sorts of news during the work week. You can get that at southernagtoday.org. I have no idea if that QR code even works anymore. It's about 5 years old at this point. And I do a blog where you could actually find that fact sheet at, because we're waiting to get it through the extension review process, but we still put it up on there anyway at agris.umd.edu. And what questions do folks have as I get my stuff up?